26 years. Auto industry. Yeah, I know they say, oh, why she in court? To all the
No, I didn't.
not you, Your Honor, but to all the listeners, because you know there's some people out here that watch this landlord tenant stuff that don't work and they just want to, oh, such and such was in court because they owe for this, but it's real out here. And mental health is real.
Court calls the case of New Park Ridge Apartments versus Alana Armstead.
Hello.
Hello, Miss Armstead. How are you?
I'm good, yes, sir.
Good. All right. Where are we on this case?
I have a balance including costs of $1,575. Ms. Armstead and I did discuss briefly this matter. She's going to make another payment of $300. Is that correct?
Yeah.
And then she's getting assistance
Through the Breeze program through Michigan Works.
Through what?
The Breeze program through Michigan Works.
Okay. So when are you gonna pay the 300?
Today.
Today. All right. So you're gonna pay the 300 and then you're gonna get assistance that you think will take care of the whole thing?
Yes.
All right. So let me adjourn this out to June 27th, 2025 at 2 p.m. for you to see if all that comes through.
All right, thank you.
All right, thank you. Court does call the case of New Park Ridge Apartments versus Karina Jones. Ms. Jones?
Yes, I'm here. I'm trying to do my video and stuff.
What'd you say?
I was trying to do my video.
No, you got it. Okay.
Gina,
all right, where are we on this case?
I have a balance including court cost of $1,901.
All right. And ma'am, how are you intending on getting that paid?
Right now I'm going through Hawk. I'm trying to figure, I've turned in all my documentation, so I'm basically waiting on a response.
You're waiting on a response from Hawk?
Yes.
No. Do you have any notes regarding that?
I do not, I'm sorry.
All right. Okay, ma'am, what I'll do, we'll give them time to see if there's going to be a response. I'll adjourn this to June 27th, 2025 at 2 p.m. Okay?
Right. Thank you so much.
Thank you. Have a good weekend.
You too.
Let's call the case of New Park Ridge Apartments versus Precious Turman.
Lillian Engen for plaintiff.
Somehow I knew Precious was in the house. Come on. Hello, what's your name?
Precious Turman.
All right. And what's the claim in this case?
I have a balance including court costs of $4,954.
All right. How are you intending on getting that?
Honestly, I feel like the whole process is a fluke because I'm low income and my rent is really only like $180 or something like that. And they're charging me market rent because they said that my recertification wasn't complete in a timely manner, which it was supposed to be done in January. I have been here 8 years and never have I had that completed in January due to the lack of them telling me what paperwork to turn in. I'll turn in a paper, they'll come back and tell me I need another paper.
Have you spoken to legal services at all?
I have not.
I'll give you an opportunity to speak to legal services since you're indicating that it's a
Yeah, 500 of this balance is coming from them trying to charge me for my security deposit, which again, I've been there 8 years.
Okay. I don't know that. I don't have it in front of me.
I have one.
But okay. That's not going to help me right now. So what I'm going to do is I want you to at least reach out to legal services or actually president in the courtroom and talk to them.
Okay.
I will adjourn this out to June 27th, 2025 at 2 p.m.
Okay.
All right. Thank you. Court does call the case of Peninsula Place Apartments versus Jacqueline Gardner. Gardner?
Yes, hi.
Hi, how you doing? I'll need a camera if you can. All right, what's the plaintiff's claim in this case?
I have a balance including court costs of $2,406.06.
Okay, $2,406.06.
Yes, sir.
All right. And Ms. Gardner, how are you intending on getting that paid? You're muted.
Yes, sorry, I had the baby in my hand.
Okay.
I'm still working with family to get it paid off. I go back to work in like 2 weeks and a couple days, and then I should be able to make some payments myself. But I'm not sure like if it can keep getting adjourned or not. from my maternity
But
leave.
you're talking, I remember, because the maternity leave, I remember, and you don't qualify because you're on maternity leave, and
Yeah.
that crazy system we have. So,
Yeah.
all right.
Sorry, I'm holding the baby.
You had your baby?
Yes, I'm holding him.
How old is he now?
It's 2 weeks, going on
That's
3.
what I thought.
Yeah.
Well, first of all, congratulations to you.
Thank you.
All right. What's the name?
Jace Jameer.
Jameer? All
Jace
right.
Jameer.
What-
Yep.
J. Jameer. Okay. All right. Well, I know she's been working with family, and this was a no-win situation for her. So the court's going to adjourn this out 2 weeks to the 27th, 2025 at 2 p.m. We'll do that in honor of the baby. Okay?
Thank you so much. Thank you.
You're welcome. All right. We'll see you in a couple of weeks. You take care.
Okay. Thank you too.
He met you. He didn't give you much of.
Courthouse case, people versus, or Faith Shepherd versus Lucreta Thompson.
Yes, can you hear me?
Yes.
Can you
Who
hear-
are you?
I am Lucreta Thompson. I am
Oh,
the defendant. I guess you get them, the defendant. Yes.
the defendant. Okay.
Yeah.
I'll need a camera.
All right, here I come right now. Oh gosh. Oh, wait a minute. How do I do this? How do I do my-
This is a
Camera.
termination.
Yes,
Sharon,
it's
if
not, it's, gosh, why have to get my camera on?
This is a termination initiated by a notice to quit for a 1 month notice to quit for a month-to-month tenancy.
All
Okay,
right.
can you see me? Okay.
All right, Ms.
Okay, here I
Thompson?
go right now. Hold on right now. I'm doing it right now. Yeah, can you see me now?
I now can see you. All right.
Okay.
This is a termination of tenancy. You had a month-to-month tenancy?
No, I have a 2-year lease, Your Honor. I've been living here for 7 years. I also have managed properties for the owners. Right now, my lease is up in 4 months. I just got a notice. I don't have a problem if she wants to retrieve her property. I mean, her property here, her residence is fine with me. But I only have 4 months left with my lease.
So hold on.
I need time.
Hold on. So you're saying it's a month-to-month?
No,
Yes, Your
I have a
Honor.
2-year
And,
lease.
ma'am,
No.
ma'am, stop. Plaintiff is saying that it's a month-to-month. You're claiming that there's a lease. I
Yes.
don't have a copy of the lease. Do you have a copy of the lease?
No, actually, I don't. I gave it to the owner's daughter 2 years ago. And I haven't had it, sweetheart. No, I haven't. So, I mean, Your Honor, I don't have it. She has it. So it's never been a month-to-month. As long as I've been living here, never been a month-to-month. I've been living here for
How
7
long
years.
have you been living there?
7 years. And I also manage properties for the owners. There are other properties that they have.
All
So I
right,
was
so
maintaining.
here's what I'm gonna do, because that's certainly a dispute as to it. So I'm gonna set this for a non-jury trial, July 1, 2025, 25 at 9 a.m. That's an in-person hearing, so you'll need to be here, ma'am. And they'll have to have somebody and show me either that there's no lease, or you'll have to show me that there's a lease, but then I'll make a decision on it, okay?
This is the first moment in the docket where the court moves beyond a routine payment adjournment and identifies a genuine factual dispute requiring trial. The plaintiff says the tenancy is month to month, while Thompson insists she still has 4 months remaining on a 2-year lease. That distinction is legally critical because the landlord's ability to terminate the tenancy and the notice required may depend on which version is true. Judge Simpson does not decide credibility immediately because neither side has produced the controlling document. Instead, he preserves due process by scheduling a non-jury trial and requiring both parties to present evidence. Thompson's biggest weakness is practical, not necessarily legal. She claims a written lease exists but admits she does not possess a copy. Her 7-year occupancy and previous property management work may provide context, but neither automatically proves the lease's current terms. The plaintiff will also need more than a bare assertion that the tenancy became month to month. Did you notice how quickly Judge Simpson stopped the interruptions and narrowed the dispute? He is signaling that emotion will not decide this case. Documentation will.
Okay, also, I'm also leaking out legal help, legal representation.
All right, that's fine. You can have legal representation come with you on that date, but I'm going to set it for trial on that date.
Thank you so very much. And you have a beautiful
you.
day. Thank you so much.
You do the same. Court calls the case Strong Future Homes versus Sajidra Moore. I got that right.
Jillian for plaintiffs.
Hello, your name?
My name is Ciatra Moore.
Ciatra Moore. Okay, I messed it up. Why are you laughing? Why are you laughing? Look at how it's spelled. I mean, it actually is spelled exactly as she said it. However, not where I would put I wouldn't break the name apart that way. Anyway, all right. I apologize.
It's okay.
All right, what's the plaintiff's claim on this case?
I have a balance including court costs of $560.
All right. And ma'am, how are you intending on getting that paid?
If I can, I would like to pay it by the end of the month.
Okay. When you say by the end of the month, what day can you?
I can pay it by the 30th, but I get paid on the 25th, but I just want to give myself some grace.
All right. Well, okay. If you get paid on the 25th, can you get it paid by what time were we set to?
2 p.m.
By say noon on the 27th?
Yes,
Can you get it paid by then?
yes.
Because if you get it paid and they know, then the case can get dismissed.
Okay,
Okay.
that's fine.
So I'll adjourn it out to the 27th, 2025 at 2 p.m. You'll get that paid before noon.
Yes. And I have to come here. Can I pay online? Or I have to.
So you can't,
How you normally would pay.
you pay, yeah.
Okay.
And if you can pay it on the 26th, that would be even better.
Okay.
Yeah.
If possible, because then they'll just ledger. And
Okay.
Hopefully it'll be dismissed and you don't have to show back up.
Okay.
And then I don't have to try to butcher your name. All right. All right.
Thank you.
Thank you.
Have
Thank
a
you.
good.
Court calls case Strong Future Homes versus Jamie Kaiser.
Jillian Engen for plaintiff.
Good afternoon, Your Honor. Andrew Camp on behalf of the defendant. Judge, today I filed an answer affirmative defenses in an appearance, and for the record, I'm personally handing a copy to opposing
Where was
counsel.
that filed?
That was filed
Filed that today?
Yes, Your Honor.
That's right.
And Judge, I do request a week to file a counter complaint. There is a cause of action under the Regulation of Collection Practices Act because this debt's been paid already. And it's pursuant to a previous case that you signed a
Now,
condition.
if it's been paid, then why can't you just work that out?
Well, we can, but
File what you want to file. June 27th, 2025, 2 p.m.
okay, I'll file that counter complaint within a week, Judge.
Well, do what you're gonna do.
Thank you.
Court calls the case of Strong Future Homes versus Alana Lindsay.
Jillian Engen for plaintiff.
What's wrong, ma'am? Were you trying to get our attention?
Yes, they call her this, Regina Agnu. I had to go to the restroom. You know, you make me so nervous. I had to get back.
Whoa. I made you nervous?
In a good.
No, in a good way. Oh.
Let my neighbor that I'm sitting by know that if they call my name, I have to go to the restroom.
You know what? I knew it was you, so I waited for you to walk out and then I called. No, I'm kidding. I'll call you back up momentarily, man. Strong Future Homes versus Lindsay. Your name?
Alana Lindsay.
All right. Where are we on this case?
Your Honor, I have a balance including court costs of $486.
All right. You were gonna get that paid. That's what you
Yeah.
told the court last time?
I just haven't got paid yet. The last court date was like last Friday, and I get paid every 2 weeks, so it just hasn't happened yet.
Okay. So when do you get paid?
Wednesday.
This upcoming Wednesday?
Yes.
Okay. All right. So it said you're gonna pay it in full by next week, but maybe that, okay. But I wasn't the judge on the case. So here's what I'm gonna do. I'll adjourn it to June 27th, my next date, 2025 at 2 p.m. Okay?
Okay.
Get that paid. All right, and then you don't have to come back and see me, so I
Okay.
don't make you nervous.
Thank you.
You're welcome. I said it. Yeah, I said that for you. Strong Future Homes versus Charles Ellison.
Jillian Ingan for plaintiff.
Oh, yeah, can you hear me?
Hello, what's your name, sir?
Charles Ellison.
All right, he's here. All right, just turn on. There you are. Okay. All right, where are we on this case?
Your Honor, we're requesting to adjourn to the next hearing date. My client's doing some recalculations on the ledger.
All right. You have any objection to that, sir?
No, sir.
Okay, didn't think you would. June 27, 2025, 2 p.m. All right?
Thank you.
Thank you. Strong Future Homes versus Chanel McFarland.
Jillian Ingan for plaintiff.
Hello.
Hello, we meet again.
What's your name?
Chanel McFarland.
Thank you. All right, where are we on this?
Your Honor, I have a balance including court costs of $6,817. I understand that Ms. McFarland is contesting it. I think that I haven't been able to take a closer look at the ledger, so I can't speak to the claims on it.
All right.
But we'll look at it and hopefully.
Go ahead, ma'am. What did you want to tell me?
Well, I was in court, this last November for the same case. My son had passed away, so they dismissed the case. But my legal aid attorney that I had, asked them to figure out how much was owed because I didn't owe them all of that. I did, put in an answer form to the clerk. I have pictures of the repairs that needs to be done and the repairs that, excuse me, that I have done.
Okay, the legal service is going to represent you at this point, you know?
He's he's out the state this week. He did send me Alex Henry.
Okay, did he say he was going to represent you?
Yes.
Okay, let me do this then. June 27th, 2025, 2 p.m. Okay, get back in contact with Mr. Henry and let's try to get that sorted out where we're going to.
All right, thank you.
Okay, thank you.
This case demonstrates why a tenant must separate several possible defenses instead of presenting them as one general disagreement. McFarland challenges the claimed $6,817 balance, says a previous case involving the same dispute was dismissed, and raises unresolved repairs. Each point could matter, but each requires different proof. Challenging the balance requires a complete ledger, payment receipts, prior court orders, and evidence of missing credits. A repair-related claim requires photographs, communications, notice to the landlord, and evidence showing who paid for the work. The plaintiff's representative also admits she has not closely examined the ledger. That concession does not defeat the case, but it weakens the reliability of the amount being requested at this hearing. Judge Simpson therefore avoids entering a premature judgment and gives McFarland time to reconnect with legal aid. That is strategically important because counsel can convert her complaints into properly pleaded defenses or counterclaims. Would photographs alone prove that McFarland is entitled to a rent reduction? Not necessarily. They may establish conditions, but the court would still need evidence connecting those conditions to the landlord's obligations, notice, damages, and the disputed balance.
Strong Future Homes versus Catrice Hadley.
Ingan for plaintiff.
Good afternoon, Your Honor.
Good afternoon. What's your name?
Shatrice Hadley.
All right. And what's the claim on this case?
I have a balance including court costs of $2,108.
All right. And the notes from last week said you were going to have it paid in full by next week.
Yes, so I have a check that I'm prepared to endorse to them today for $1,000, and my refund check is supposed to be deposited any minute now.
Refund from
School,
where are you in school?
Henry Ford College.
I don't know that. All right. What are you studying?
Social work.
We had enough of those. All right. Okay. So you got your refund check coming in. You have $1,000 now.
Yes, sir.
Okay. But I don't know. They can't take a third party check probably.
Your Honor, I don't know what the negotiable instruments do anymore. I think probably, since it's gonna be adjourned for 2 weeks, Ms. Hadley, if you could maybe,
Okay.
yeah, cash it or,
Check.
That's fine.
Okay,
That's fine.
yeah.
then here's what I'll do. I'll adjourn it to June 27th, 2025 at 2 p.m.
That works for me. Thank
If you get that $1,000 into them and then and your refund comes through, then you get it paid, then you don't need to be here then.
Yes, sir.
All right?
Okay.
Okay,
Works
thank
for
you.
me.
How are your grades?
Really good.
Really good? Okay.
I'm proud of myself.
Don't you, you know, when
45 and back in
you see
school.
the smile on their face? Oh, yeah.
I'm doing great.
Fantastic.
Thank you.
All right, you take care. Strong Future Homes versus Candace Long.
And for plaintiff, Your Honor, Defendant Anthony Long was here earlier. He had to go to work. He says he's going to pay the balance in full on, I think it's Monday. Obviously, that's within the 10-day period. I told him that I told him that I would ask the court for a judgment, but we would set it aside if paid in full on or before June 3rd, 2025.
All right. So what is the claim?
The balance rent to retain possession is $717. Court costs are $222 for a total of $939. The redemption date is June 23rd, 2025, and it will be set aside if paid in full on or before June 23rd, 2025.
All right. I'll issue a judgment for possession. I'll do it by default. Redemption amount in the amount requested with the rich issue in 10 days. That will be set aside if it's paid. Strong Future Homes versus O'Day.
Jillian Agan for plaintiff.
See, I'm gonna make you wait.
Good afternoon, Judge Simpson.
Good afternoon. What's your name?
I'm Lolita O'Day.
All right. And what's the claim in this case?
I have a balance including court costs of $909.67.
All right. Ms. O'Day, how are you gonna get that paid?
I talked to Hawk and I'm waiting on my SER, but I was just at court, it's $800 and some dollars. Like, I don't know. This
It
is
looks
from
like
20,
it looks like a late fee might have been added.
this is from 2023, Your Honor.
Okay.
I mean, I don't know. They never told me nothing until now that I owed it this back money. And I just got
Okay,
the
do you
bucket to
think you
legal
don't
way.
know it? Or
I don't know. I can't even remember what I ate in March of 2023, Your Honor.
what you ate in March of 20?
I don't know.
If you could even remember that far back. Because what was this morning? What did I have this morning? So yeah, that's as far back as I can go.
That's why I'm in court for 2023. I don't know. I just got my ledger from Tanisha. I got all my
Okay,
papers.
so
I don't
did you want somebody to help you go through that? Did you want to talk to legal services
Yes.
about going through that?
Yes, sir.
All right, so here's what I'll do. Let me adjourn it June 27th, 2025 at 2 p.m. That'd be an in-person hearing. Get with them, go through the ledger. Let's try to figure it out, okay?
Okay, you said June
27th.
At what
That's at
time?
2 p.m.
2 p.m. Thank you, Judge Simpson.
You're welcome. Now you take care.
I'm at.
What did you say?
Thank you.
What'd you say?
I said I will. I will take care of it.
Okay, you have a great weekend.
Yes.
All right. Did I make you nervous?
True. Yes.
Wow. Oh. You did not have to sign on to what she was saying.
When a person ain't never been through none of this, Simpson, you know, I watch you a lot and you're very, very, very fair. And I love that.
Thank
But I don't know, I'm just shaking.
No, I got you. Thank you for saying that. I appreciate that. Turn around and tell her that. Sparrowwood Apartments versus Regina Agnu.
Jillian Agan for
I was gonna make her wait to the end.
Oh, I thank you. God is good. I thank you because I want to go to work. I said, Lord, if you let me be out of here by 1:30, I don't have to call off because I need the money.
You are just gonna hold church up in here, aren't you? All right. What's your name?
Regina Agnu.
All right, thank you. All right, what is plaintiff's claim in this case?
I have a balance including court costs of $1,504.90.
All right, Miss Agnew, how are you intending to get it?
I talked to Robert G earlier, this morning about 10ish, and I went on the portal because he straightened some things out for me where I can go in, and I paid $200.90, which came out to $206.91 because of 2.99%. That's a lot of extra money. $6 is a lot in this economy. But anywho, to make that payment, I had stated to him that on the 20th, I would make a payment again, and I will be all paid up by the 27th. So on next Friday, I will make a payment of $550 and the remainder on the 27th. Now, what I would like to say is, I understand business is business and they need their money. When I moved in the end of March, six days before the end of March, my door is, how would you say? I would say jimmied by the maintenance person, the sliding door, where if someone really wanted to get in my home, they could. And if I could just put it in escrow so they know that, okay, I know it's business, you bringing me to court. Yes, I owe you this. Yes, I do. But please make sure that my living quarters are good per the state guidelines as well, because they told me that it would take, the guy that came out and measured the door. You can. The gentleman that came out and measured the door said that they had been telling them, Empire Management, with the prior tenants that lived in that particular unit that I'm in now, that they would need to replace the door. And the door has not been replaced yet. And today is, you know what, June 13th. Thank God I'm not superstitious. And it has not been replaced. So to be fair,
you need the door replaced.
I need that door replaced. I haven't been holding funds because of that. It's just other things that's been going on. And I just returned back to work on this past Tuesday due to.
What do you do for a living?
I'm in the auto industry, 26 years. Auto industry. Yeah, I know they say, oh, why she in court? To all the
I didn't say that.
Not you, Your Honor, but to all the because you know there's some people out here that watch this landlord tenant stuff that don't work and they just want to keep, oh, such and such was in court because they owe for this, but it's real out here. And mental health is real. I have lost people, but I'm saying this for the viewers too.
Oh, so now you better talk. Go ahead, girl. You know what? I could not stop you. Just go ahead. I figured she wasn't talking to me, so go ahead.
No, you good. You're right here. You're right here with me. You're right here with me. You just make me nervous. Well, I have to keep going back to the bathroom while I tell my neighbor. If they call my name, please tell them I just went to the restroom. But I haven't been holding money due to what they owe, but they're coming down hard on me. So since we're going to be hard about it, please take care. You shouldn't even okay for me to move in when I did and things was not taken care of. That's all. That's all I'm saying. But I will have this satisfied by the 27th, and I look forward to seeing you. If I have to come back in here in court, I hope not, because my shift started at 2:30, and I don't have to call in because God is good, because I'll be out of here. But we as people,
you just let me know when
you're
finished.
So we as people in the auto industry, we go through things too. I just want the viewers to know. Yes, I thank God for my employment. I was able to raise my children up on it, but there is things that goes on in life.
Okay, all right.
Thank you, Your Honor. I appreciate you.
And you. Did you want to say anything, Miss?
Your Honor, I don't know if I can follow that up. Is it the latch? Is it just not latching?
It's what it is it's the sliding door, and so you have the door that latch, but the back side of it is a gap. Rodents can get in, so they put cardboard in there.
I see.
And they told me they ordered the door, it would take 6 weeks. So we're 6+ weeks out. And I just need communications, everything, like they tell me, and I agree.
Thank you.
But I'm not holding rent because of that. But since we in here, let's have a conversation about it. Respectfully.
Okay, did you want, you mentioned, I almost don't want
escrow.
You want to put it in court escrow?
And I do.
All right, so you need
next Friday. I will come to the courthouse and I will put that $550 in. And the following Friday, on the 27th, I will pay the remainder. And I tell you, Your Honor, you will not see me out of good faith in July, because July will be on time.
Thank you, ma'am.
You're welcome.
All right.
I appreciate you. I do.
June 27th, 2025, 2 p.m. All right.
Okay, thank you.
You take care and know they'll make sure to
Have a
get
great
in your door. Really? Oh my God.
The final hearing captures the central pattern of this docket. Judge Simpson is willing to provide additional time, but he repeatedly requires concrete payment dates, supporting records, and realistic plans. In Regina Agnu's case, she acknowledges the balance, identifies specific payment amounts, and proposes depositing money with the court while raising a serious sliding door repair problem. Her explanation is lengthy, but she makes an important legal distinction. She expressly says she has not withheld rent because of the defective door. That prevents her argument from appearing to be a retroactive excuse created only after the non-payment case began. The repair issue may still carry legal significance. A defective exterior door, a gap that may allow rodents to enter, prior knowledge of the condition, and an alleged delay exceeding 6 weeks could support a repair or habitability claim if those facts are documented. However, the condition does not automatically eliminate the unpaid balance. Judge Simpson therefore keeps the payment dispute moving while also pressing the landlord to address the door. The court adjourns the matter until June 27th, allowing Agnu to deposit $550 and pay the remainder rather than immediately entering a possession judgment. Across this docket, the lesson is consistent. Promises become persuasive when they include dates and amounts, disputed balances require detailed ledgers, and repair claims require evidence. Which tenant presented the strongest legally credible plan? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.